just want to start off by introducing myself. My name is Christian Gaddis. I am the Senior Manager of Marketing and Recruiting for Forge Buffalo at 43 North. I want to thank everyone for joining us on this Small Business Schooll session, the ABCs of Business Law. Before we get started, I just want to take care of a few housekeeping items. We're going to be holding 15 minutes at the end of the presentation for just a quick Q&A session. So if you do have any questions, please use the Q&A feature on Zoom. We're not going to be checking the chat for questions at all. So just make sure if you have anything you want to ask, you put that in the Q&A. And then we are also recording this session, and we will be sharing out a link via email, and it will be posted on the 43 North YouTube page. So be sure to check that out if you want to kind of revisit it or, check back in and see if anything, or share it out yourselves with anyone who you think might be interested in it. So with all that taken care of, I want to go ahead and introduce Matthew Pelkey. He's the Program Director of the Entrepreneurship Law Center at the UB School of Law. And Matthew, go ahead and take it away.
Thanks, Christian. I appreciate you having me this morning and for setting this up. And thank you very much, everyone who is joining us today. Real quick, I need to make my malpractice carrier happy. So this is a quick disclaimer. I am an attorney. I am licensed to practice. And so one of the important pieces here is that what we're talking about today is not meant to constitute legal advice to you. Everybody's individual facts and circumstances are unique. And if you have an issue that you're facing or you have questions, we'll answer those today, but you really should contact an attorney about advice as to your particular facts and circumstances. Also, the presentation today doesn't create attorney-client privilege or attorney-client relationship. Anything you discuss today is obviously not going to be subject to attorney-client privilege. And of course, the opinions expressed are my own and not of any organization or UB. So if you didn't read that, hopefully my summary of it at least gets you where you need to go. So now that my malpractice carrier is happy. As Christian said, my name is Matthew Pelkey. I'm the Program Director, and I'm also a clinical faculty at the Entrepreneurship Law Center at the UB School of Law. I'm a partner at Colligan Law, LLP in Buffalo. In 2013, I co-founded Black Squirrel Distillery, which we sold in the fall of 2019. Really great time to sell a business in terms of what happened in 2020. And then I also act as a mentor, advisor for a number of startups and small businesses, serving on boards, giving advice, helping mentor businesses and tackle not just legal issues, but business issues as they come up, including some of the businesses that I invest in as well. So what we're going to cover today, just so that you kind of have an idea of the issues we're going to tackle. So if one of them interests you in particular, you can kind of make note of it. We're going to cover areas that are common areas where businesses either make a mistake or need help, especially in light of the last year. And so first and foremost, we're going to talk about labor and employment. This is an area where small businesses can get themselves in a lot of trouble. Taxes and insurance, some intellectual property issues. We'll touch on entity choice and structure and how that can impact your business. A little bit on governance, not the most exciting topic, but it is an important one, especially for your attorneys and accountants and professionals. And then last but not least, finance. My JD and my background is a lot in finance and M&A, investor finance. And so it's a topic, obviously, that I follow closely. So labor and employment issues, as I noted, are one of the most common pitfalls for businesses. And the key that maybe not everybody recognizes is that you can actually, as a business owner, even if you have a corporate entity or an LLC, be personally liable for unpaid wages and benefits. So while you think you might have protection from some of these things, right? You spent the time, you formed an LLC, maybe you did it on Rocket Lawyer, or you actually had a lawyer do it. That doesn't protect you in the event that you have unpaid wages or benefits. Your employees could actually sue not only the business, but you personally. And that goes for LLCs and corporations that are doing business in New York. It used to be for a while that it was just corporations. And then in 2014, New York State passed the Wage Theft Prevention Act, really meant to protect employees. And so one of the issues I always say here is that if you have the best of intentions and maybe you don't want to lay somebody off, but you're facing cash flow shortages, you're in a much better position if you lay that employee off and rehire them than you are if you just defer their compensation and don't pay them. And there's a lot of people who have great intentions on making that up at some point. But the reality is, what can start as maybe a few $100s can quickly turn into thousands and tens of thousands of dollars that not only is the business liable for, but now you personally as an individual are on the hook for. So something to keep in mind as we go through some of these labor and employment issues. These are probably the most common issues to take note of as a small business. Independent contractor, and we'll talk a little bit more about that, minimum wage, minimum exempt wage, New York sick leave, hiring documentation, sexual harassment and training and discrimination laws. So with independent contractor, the issue really here is that people have this tendency to believe that as they just call somebody an independent contractor, they don't have to treat them as an employee. That sounds well and good, but the reality is that the Department of Labor, both the state and federal level, are not going to agree with you on that. This is a really nuanced test. And what it ultimately comes down to is whether or not that individual is actually independent. Do you as a business owner exercise control over them? Do you control their schedule, their manner of work? Do they have other clients that they work for? Are they dependent upon the business? This is a multi-factor test, and the more factors that weigh in favor of someone looking like an employee, Department of Labor, both at the state and federal level, are going to treat that person as an employee, even if you call them an independent contractor. And the problem with that, of course, is that if you have been treating them as a contractor and not an employee, chances are you haven't been withholding payroll tax, you haven't been utilizing unemployment insurance, workers' compensation insurance, disability, some of those things we'll talk about. And once one of these things gets triggered, it really starts sort of a waterfall of issues that come up. And really what it takes is oftentimes one disgruntled individual who maybe puts in a claim for unemployment insurance or calls the Department of Labor. And, the fees and fines that can add up from this really can be tens of thousands of dollars. And so, what might be, penny wise quickly becomes pound foolish, right? Minimum hourly wage laws. I'm putting this in here because this just changed. If you are not aware of that, you're about 21 days past when you were supposed to start increasing the minimum wage. It is now $12.50 an hour. There are some nuances there depending on the industry specifically you are in. I doubt we have any franchise owners on here, but to the extent we did, it actually, I think now is for franchise fast food, it's actually $15 an hour. Minimum wage exempt salary. Most people, who are looking at exempt think, well, I can just pay somebody an exempt salary and not have to worry about minimum wage and hours. That has increased. It is now $48,750 or $937.50 a week. And understand that you can't just treat anybody as exempt. There are specific qualifications for who can be an exempt employee. You can't just make somebody exempt because you don't want to have to pay them overtime. It has to be somebody who fits the specific, definition of an exempt employee. And that is a nuanced analysis in New York State. There are new New York sick leave laws. This is based on the number of employees you have. And so essentially, the larger you are, the more benefit you have to provide. The smaller you are, sort of on the lower end of that, you just have to provide up to 40 hours of unpaid sick leave. What does that mean? It means you can't fire somebody if they take a week off for being sick. And this actually came out as a result really last year of COVID, and wanting to protect people in the event that they got COVID or they were sick, and so that employers couldn't terminate them as a result of that. Obviously, it has other applications as well, but that really was the impetus. Hiring documentation. I think most people are getting better at this point, but New York State and the federal government obviously have a lot of documents that you have to fill out as you hire somebody: W-4, wage notices, I-9s, and then the New York State withholding form. The wage notice seems to be the one that people sometimes fall short on. Not only should you have that filled out inside at the time of hiring or if there's an increase in wage, but you need to make sure you give your employee a copy of that. Sexual harassment training. I'm hoping everybody is aware of this one at this point. We've now had it for a couple of years, but an important thing to note on this has to be an annual requirement. And while there has not been a lot of clarity on what happens if you don't do your anti-sexual harassment training, obviously you don't want to be the test subject on that one. It's super easy to do. There are resources out there that don't cost a ton of money. Frankly, the New York City Bar, I think actually has a free online one, but you should consult a lawyer as to, exactly if that fits your circumstances or not. And then discrimination laws, New York in particular does have a fair number of anti-discrimination laws. In particular, you cannot discriminate in hiring someone or terminating someone. So if, there is an employee that you don't want to hire, or there is an employee that is performing poorly, this comes down to really just making sure you document that appropriately. If somebody's not performing well, make sure that you put in writing and state, either a warning or put it in their file. You want to have as much record as possible when it comes to this, so that it's clear that the reason that somebody was terminated was because of X, Y, or Z, and not because you're discriminating against them. And obviously it goes without saying, don't refuse to hire people, and don't terminate people that would be in violation of anti-discrimination laws. And one thing to note on that as well, there are a broad number of categories in that. Everything from race to sex to gender identification. Gender just passed in the last couple of years in New York State. So it is pretty broad in terms of what New York State law protects from discrimination. Another point, there seems to be some misunderstanding that if you call somebody an intern, you don't have to pay them. That is patently false. There are circumstances where somebody does not necessarily need to receive income as an intern. However, that person cannot be taking the place of someone who would otherwise be an employee. They need to be a burden on the business. The business cannot be extracting value from that intern. The best way to think of this, I remember when I was in high school, I wanted to be a graphic designer, and I ended up going and shadowing an employee at Bombardier who did their graphic design for the company. And all I did was basically follow that person all day long and watch what they were doing. That was an unpaid internship. However, if that person is providing any value for the company, they need to get consideration. Now that can be minimum wage, but you don't want to get in a scenario where you're having somebody there who you're just calling an intern because you can't afford an employee and having them play the role of an employee. You can get yourself in trouble with that. Again, going back to minimum wage laws and all the fun rules that come along with that. And I see we have some questions on that one, so that'll be fun. We get to it at the end. Employment agreements. Not every employee you need an employment agreement with. If you are, in the hospitality or a restaurant, you probably don't need an employment agreement with a server or with a receptionist. This is meant to cover usually higher level employees, who maybe are managing or directing things. One key thing, if you are going to have employment agreements, make sure it specifically states that the employee is at will. If you don't, it may be interpreted against the company that they're not, which actually means they're entitled to their job. This is why employment agreements can kind of cut both ways. If you DIY it, you can get yourself into trouble. IP, which we'll talk a little bit further down the road, intellectual property, to the extent that that employee is creating IP, say they're designing a program for your company, or they're managing, some sort of application or technology on the back end, those rights exist at the employee level. The employee is the creator of that intellectual property. So you want to make sure that that IP gets assigned to the company and the company owns it. NDAs can always be a little bit controversial. I think most people think of these in the context of, oh, you're trying to cover things up. But the reality is they're used every day by businesses, especially if an employee is, has exposure to important aspects of the business, financials, trade secrets, intellectual property, customer information, the secret sauce of your business. You want to make sure that's protected and that that employee can't leave and go give it to your competitor. NDA is a perfect way to do that, and it's used every day, obviously working with an attorney. The last two here, non-solicitation and non-compete, those I would like to call restrictive covenants. NDA is as well, but these are a little bit more teeth behind them. Non-solicitation basically just protects the business in the event the employee leaves from going out and soliciting not only your employees, but also potentially your customers. It's not quite the same thing as a non-compete. And so it's a little bit less scrutinized than a non-compete will be, but it is something you often see. And then last but not least, non-compete. The thing with non-competes is that they are going to be heavily scrutinized in New York State. And under most circumstances with employees, they're likely not going to be enforceable. There are instances where they can be. But if you're thinking that you can slap a non-compete on every one of your employees and prevent them from going to your competitor, you're likely going about that completely wrong. New York State does not want to prevent people from being able to work. And so if you have, let's just go back to hospitality. If you have a server or even a cook in the kitchen, and you make them sign a non-compete, and then they go work for another restaurant down the street, and you try and sue them and prevent them from working there, that's not going to be held up in court. Now, if you are developing products, or you have, for instance, we'll talk about Black Squirrel Distillery a little bit. We were one of the first distilleries, certainly in New York State, and I believe one of two in the entire country, who at that time had created a spirit from maple syrup. Our team spent a ton of time creating the recipe for that, figuring out the process to actually make that work, and that became a trade secret of ours. And so the employees who were working with that recipe, who were working with that technology, not only had NDAs, but had non-competes, but they were very narrow, right? We weren't saying that they couldn't go work for, any alcohol and beverage company. We said, you're not permitted to go work from somebody who's going to make this same product in this same market, maple-based spirits, right? And so the more narrowly tailored you can make that, the better. Now, that was only the employees who were working with that recipe and had the knowledge of that technology. They had some special skill set. We weren't doing this to people who were on our marketing or our sales team, right? Taxes and insurance, the sort of golden rule. I started out with one golden rule here, but then it became two, and I was like, okay, well, I got to make it two, which I guess is no longer a golden rule, but there's two of them here, so we're just going to ignore that for a moment. Always important to work with a good accountant. This is not the same thing as a tax preparer. This is not the same thing as a bookkeeper. You really should have an accountant that you can call, ask tax questions with, who will help you with tax planning, who will look and say, okay, here's how you can position your business to take advantage of X, Y, and Z. Can save you a ton of money and frankly, save you a lot of problems down the road. Another key piece here, and this is more looking to avoiding problems, always file your returns. Even if you're not going to be able to pay the income tax on that, always file. And the reason is that actually starts the clock for the statute of limitations to run. And that can be beneficial if you get yourself into a problem where you're trying to work through a turnaround situation or a restructuring or a bankruptcy. The clock doesn't even start ticking until you file those returns. And so if you've got multiple years where you haven't filed tax returns, you're not avoiding that indefinitely. You're just kicking that can down the road until you actually do file or there's an event, and your liability is just compounding itself. Next, payroll tax withholdings. Always use a payroll company. Some people like to do this themselves to save 30 or 40 bucks a month. But the reality is, it's really easy to mess up the payroll withholding tax. And the penalties for that are substantial. It is not worth saving 30 bucks a month to avoid using a payroll company. Sales tax, make sure you are segregating funds. Make sure you are paying on time. If you pay early, you actually get a discount. Make note of that. This is something not to mess around with. Much like employee wages and benefits, not only can this lead to civil penalties, but it can also lead to criminal charges. You can lose your driver's license in New York State as well as other privileges. New York State does not mess around when it comes to sales tax. So definitely make that a priority. And then in terms of insurance, obviously general liability insurance is important. Depending on what industry you're in or the market, you might look at products liability insurance, really just some ways to cover the risk. If you have any employees, and frankly, if you're using independent contractors, you really should look at having workers' compensation insurance, unemployment insurance, and disability. And somebody's like, well, why would I have that if I have an independent contractor? I have an independent contractor to avoid having these things. Well, in the event that you have misclassified that person, right? These are the things that New York State will go after you for not having, and your definition of an independent contractor likely will not be the same as the state's. So, as I noted, there are a plethora of possible violations and consequences that can come up for running afoul of most of these rules. Everything from federal to state, IRS regulations, Department of Taxation, criminal charges, civil lawsuits. Obviously, it can impact turnover, penalties and interest, personal liability for owners, and inevitable end once you've gone through most of these is that you end up in some sort of bankruptcy or turnaround situation. Intellectual property, I'm not going to spend a ton of time on IP. There's a lot we could talk about, but I think it is important to sort of have some broad overviews and discuss where that intellectual property exists. IP refers to broadly sort of 4 categories, although I'm lumping 2 of them together here: trademarks and copyrights, patents, and trade secrets. Trademarks, copyrights, and patents are statutorily defined protections. These exist under federal law, although trademark actually exists in both federal and state law, although there's limited protections if you're just filing in New York. Trade secrets sort of encompass everything else, right? And the best way to think about this, trademarks and copyrights are words or images. Patents are technologies or concepts, ideas, designs. And then trade secrets being everything else. One way to visualize this, trade secrets are, the spices that go into KFC's seasoning, right? That's like the easiest one people think of, or the recipe for Coca-Cola. You can't statutorily protect those things, but what you can do is put in place things like non-disclosure agreements, non-solicitations, non-competes to protect those things internally at your company. You can use contract law to actually protect those things. And I will note in 2016, there is an act that was passed called the Defense of Trade Secrets Act. It doesn't give you the right to register those trade secrets, but what it does is it puts a lot more teeth and consequences into an employee walking away with those trade secrets. Really good example of this actually is there was an employee from Google who actually just got pardoned by President Trump 2 days ago, Lewandowski, who was left and took a bunch of the LiDAR technology from Uber and Uber's subsidiary, and basically ended up not only civilly getting sued in the Northern District of California, but ended up with criminal charges and ended up, was facing prison sentence until he was pardoned. So trademarks and copyrights, these get registered with the USPTO, which is the US Patent and Trademark Office. If you have a particularly unique name or a catchphrase or something that's trademarkable, and that is sort of a nuanced analysis that I'm going to save for another day, you can register that with the federal government, and it gives you protections from somebody stealing your name or a competitor using it. And the nice thing about having it statutorily protected is that you actually can get statutory damages. You could potentially get attorney's fees. There are some real teeth that get put in behind that. Trademarks, again, are names or the design of a trade name. Copyrights are for mostly images and works of art. These are actually really simple to register. If you are in a business where you're producing a lot of copyrightable material, register it. It's like $30 to the USPTO, and there is no substantive review. You can upload it, you can pay the fee, and you now have that protected, especially if you're a photographer or you're an artist or you're in a space similar to that. Make sure you're copyrighting your IP. Patents, obviously a lot more expensive, a lot more complicated. You need to work with a patent attorney on this. I am not a patent attorney. I know just enough to be dangerous. But one thing to note about patents, you have 1 year from the time that you publicly disclose that technology to actually file that patent, or it becomes unpatentable, essentially, at least by you. And so, if you have been utilizing a technology and it's out there and you put it on your website or you put it on social media, your clock is ticking. And frankly, if it was over a year ago, your clock is already ticked. And so that is something to speak to a patent attorney about. The cost of patents can be substantial. You might be looking anywhere from $5,000 to, 25, 30, 50,000, depending on the space you're in. Obviously, the more complicated the technology, if we're talking about a pharmaceutical patent or biochemical patent, those can be substantial costs. And then we discussed trade secrets. So that's really the difference here. Just something to think about as a business so that you're protecting your intellectual property. Especially if you ever think about selling your business, these are things that people are going to want to see. There's value in your trade name and your brand, the images that go along with that. There's value in the technology. And then to the extent that there are trade secrets, there's value there. And a buyer wants to know that those things are protected and that they own them. Entity choice. The key thing here, I suspect most of you are, have entities formed at this point, but it is important to understand some of the differences and maybe what you're doing and maybe what could be done differently. The first I'm going to start with is default entities. Some people think just because they haven't formed a business that there isn't a business, but you can have accidental businesses. You can have accidental partnerships. If you are a sole proprietor, you are a default entity. You don't need to form an entity to actually have a business. If you are taking steps towards a for-profit purpose, you're a sole proprietor. If you're doing that with multiple people, you're a partnership. And sometimes people can actually do that without realizing it, and that can create some problems. Corporations, this essentially breaks down into S corps and C corps. The same legal structure. The S and C really just refer to the tax structure. S doesn't stand for small corporations. S actually stands for the subchapter in the tax code that it is placed in. C corp is the default entity. We'll talk a little bit about both these in a second, but those exist. LLCs, these are very common for small businesses. These are limited liability companies. Very similar protections as a corporation, but a little more flexible. And then I did want to throw in here, because I suspect we have some folks on here who either are interested in this or frankly may be these things. You have in New York State benefit corporations and then also cooperative corporations. They are in their essence still corporations, but they get some special treatments and they have some unique aspects to them. Not going to cover them a ton in detail today, but if anyone has any questions about them, feel free to throw it in the Q&A and we can cover it at the end. So comparing entities. First, one of the biggest things, especially for small businesses to consider, is the tax implications of each entity. When you're looking at default entities, such as a sole proprietor or a partnership, you're going to have pass-through taxation. There's no entity to tax. S corporation is also going to have pass-through taxation. They actually get favorable tax treatment compared to C corporations. However, there are a lot of strict limitations on what can be an S corp and who qualifies to be an S corp. So that's something to think about and talk to an attorney about. C corporations, you often hear people talk about double taxation, and that's the downside from a tax perspective of C corps. That is true. But there are some things to think about in terms of double taxation versus pass-through taxation. And then last but not least, LLCs also have pass-through taxation. So I said there was some considerations. There are. And what this really comes down to is actually self-employment tax. And so there are pass-through entities, right? You have partnerships, you have S corps, and you have LLCs. Those are pass-through entities, but you're likely going to have to pay some form of self-employment tax. And so the whole concept of avoiding double taxation in a C corp starts to become a little bit more murky when you factor in the fact that you're going to have to pay self-employment tax. And so when you break it down, what I like to say is these are really spreadsheet decisions with your accountant. Talk to them, figure out which entity makes the most sense for you, because there are certain tax deductions that you can get in some and not others, right? An LLC, you can get qualified business income deduction. Or a C corp is going to have a lower taxation rate. And if you're a company where you're paying yourself a W-2 wage and the company doesn't retain a lot of cash, well, the double taxation issue kind of becomes moot because there's no actual net income at the end of tax anyway. And so really one of those areas where there's a lot of generalizations, but the real sort of situation for you needs to be discussed with an accountant and figured out. Liability, sole proprietors and partnerships, I hate to break it to you, but you are unlimitedly liable, and you are also joint and severally liable. That means that if you have any sort of liability, a debt, an injury, somebody slips and falls on your property, there is no limit to the liability that you can sustain. And for partnerships, this is particularly noteworthy because you actually can be liable for the actions of your partner, within that partnership. So it's not just your own actions. Fortunately, S Corps, C Corps, LLCs all have limited liability to the extent that you respect the corporate form. And so when we talk about governance, you can see at the bottom line, there's governance. A New York State court will disregard the limited protection of your entity if you are not actually treating it as a separate legal entity. It's called piercing the corporate veil. And it happens when a court essentially says, you know what, you're treating this entity as an alter ego of your personal self. And because of that, we're going to disregard that entity. It's a little bit complicated of an analysis, but it's out there. And it's one reason why when attorneys tell you, you've got to make sure you're doing proper governance, that you are keeping minutes, that you're having meetings, that you're taking all these steps. That's why. Costs. So if you're thinking about switching or filing, or maybe you were in one and you want to create a new entity, the nice thing about sole proprietorships and partnerships, really cheap. Technically, you don't have to spend anything. If it's a partnership and you want to use a different name, you can file a certificate of a partnership with the county or a DBA for $35. Corporations are essentially $125 filing fee in New York State, plus whatever you might spend in attorney's fees. You can try to DIY it. Obviously, if you use a site like Rocket Lawyer or LegalZoom, which I'm not recommending, but I'm not going to be naive that people don't do it either. You are going to have to pay some fees on top of this. LLCs are going to cost a little bit more. It's about $250 total in filing fees. And then you also have what's called publication. And these are the things that need to be done for your LLC to actually legally be set up properly. Publication costs can vary depending on what county you're in, around $350 if you are running a business at a downstate in Manhattan or New York City somewhere. Obviously, those costs can be considerably higher. The county clerk for each county actually approves what publications qualify. Governance. With a pass-through entity, with a default entity like a sole proprietor partnership, you essentially have no governance. With S Corp and C Corp, you do have a much stricter governance that you need to comply with. LLCs, you have some governance, but it tends to be a lot more flexible because a lot of that is based in contract in your operating agreement. So governance, I have emphasized why it's important. Your lawyers and your accountants are always going to tell you good governance is important, and it is. Now, it might look different depending on the size of your business, but the essential idea of it all really comes down to these points. Number one, make sure you have your proper structure in place, right? Make sure there are owners and then there are directors or managers, and those are separate things. They may be the same people, truthfully, they may be. But those roles are separate, different legal roles. And so having a formal board of directors that can be just the people who are owners, that's fine. If you are a sole proprietor, if you're a single owner and you have a corporation or LLC, you may be the only one who's a director and a manager, but having those things set up are important. And obviously the larger your business gets, the more important these things are. And taken to an sort of, extreme, once your business gets large enough, having independent directors is a great thing. Creating directors who can help govern the company is a great thing. That can really help improve the accountability and the transparency of the business. Hold regular board meetings. At a minimum, these should be held annually, where you are documenting who is being appointed as directors or managers and who's being appointed as officers. Those things are important. It's a one-page form. It's really easy to do with a lawyer. It doesn't cost you a ton of money, but it's important to have these things. And you know what? Things like banks are going to want to see this if you go for a loan, if you're going to sell the business, all of these things will come up. As I noted, record keeping minutes, keeping copies of your resolutions. Lawyers like to refer to this as your minute book. It doesn't have to be a physical book. I've sort of moved away from the black binders that people used to use and are now mostly using digital records for people. It tends to be a little bit easier. Utilize advisors and mentors. Maybe you are the only owner and the only director of the business, and that's okay. But that doesn't mean you can't set up an advisory board. Who are people that can help you hold yourself accountable, who can look at the future of the business, where it's heading, help you solve problems. And of course, if you're going to be discussing those things with advisors and you're putting together an advisory board, it helps to have a formal agreement, have things like NDAs. And then last but not least, I'm putting this in here because I've seen people get in trouble with this. Understand your fiduciary duties as a business owner. If you are a director or a manager of a business, you have a fiduciary duty to that business. Now, if you're just the only business owner and nobody else owns it, kind of academic because while you might breach a fiduciary duty, you're only breaching it to yourself and it really doesn't have an impact. However, if there are multiple owners, this starts mattering. You have a duty of care, which means that you will put in the effort that is reasonable to keep yourself educated about the affairs of the business. Things like board meetings help show that you are exercising a duty of care. If you go multiple years without having any meetings and you don't look at any records and you don't keep financials, you are arguably not satisfying your duty of care. More importantly, duty of loyalty. This is where people actually get themselves into trouble. There is something called usurping a corporate opportunity, and in which you as a director or manager are not being loyal to the business. And that means if an opportunity arises and you pursue that personally or with another partner or with somebody else, you actually could be liable to the business and the shareholders for that. And the profits from that venture could actually be put in a constructive trust for the benefit of the company that you just breached your duty against. It also means that if it's a large enough amount of money, the business and your partners in the other venture are likely going to sue you, and depending on the circumstances, may actually be able to get what's called a temporary restraining order, which prevents you from actually pursuing that other venture. And if you were doing it competing with your business, you may be in a situation now where your source of income has been cut off. Now, that's not to say you can't ever go out and engage in competitive behavior with your own business. The key is that has to be disclosed to the owners and the directors. It has to be discussed and it has to be approved. And at that point, you can go forward. But you can't usurp that opportunity for yourself without disclosing it to the business first. And I have seen a number of people get in trouble on this. So it is something to keep in mind and make sure you don't run afoul of. All right. Financing is sort of the last major piece here. Financing essentially breaks down, at least in my mind, into three categories. You have self-financing, you have loans, and you have grants. There's also investor finance. That's a whole other topic. We can talk about another time if you want, but for purposes of small businesses, this is really where they fall in. Self-financing is pretty straightforward. Your savings, your loans from your 401k, home equity loans to finance it. This is where you as an individual are finding capital to put in, right? More importantly, right now, we'll talk a little bit about loans and grants. There are I'm not going to lie to you, right now is a difficult time to get a loan as a business. But there are sources of financing out there from commercial lenders. WEDI has been a great source. ECIDA can also provide loans. There are EIDL disaster loans. And then the SBA does have some specific loan programs, their microloan program and their 504 loans. Those can help, especially if you're looking at expansion projects or involves real estate. And then last but not least, grants. This has been a challenging year, no doubt, for all businesses, but especially small businesses. And taking advantage of as many grants as possible is helpful, right? And so you obviously, most of you, I believe, had some awareness of the program that 43North ran last year, but there are other programs. There's the Raising the Bar for New York State restaurants. There is a second round of EIDL grants coming out. Those were supposed to go live on Saturday. That didn't happen. I've been following some of the chatter on what exactly is going to be going on with that. But what it looks like right now is that if you previously applied for an EIDL loan or grant advance and you didn't get the full 10,000, it appears that they're going to give you the difference between what you got and the 10,000. But you need to be in a low income census tract or county, and you need to have less than 300 employees. There's not a lot of details out about how this is going to happen, but that is essentially what has been discussed at a high level. There has been some indication that there won't be an actual application, that essentially if you already applied, they're just going to pull your data from that, and whoever didn't get the full amount, they're going to look at the demographics, and if you fit, you'll get the balance. There are a bunch of workshops going on with the SBA, literally as we speak, I believe today, the rest of the week. And so if you're interested in that and you have some more questions, you may want to check out some of those workshops. There are additional grants. ECIDA does have a PPE reimbursement grant. If you haven't already, while it's not technically a grant, the second round of PPP loans came out, opened on Tuesday, I believe. You really should apply for that. It can be a grant. It can be, not only forgivable, but not having to recognize income from it, which is pretty fabulous. And likewise, the EIDL grant doesn't count as recognized income either. Both really great tools. And if you haven't applied for a PPP loan previously in the first round, maybe you forgot, maybe you didn't get in time, it is conceivable that you could get in on the first round of PPP loans that opened up last week and still get in and have a second round available assuming there are some funds left. So don't sleep on that. I know there was a workshop earlier through 43North Small Business Schooll that touched on it, but these are really good resources of capital. And right now I know a lot of the hospitality industry, you're facing the lean months, right? And so whatever capital you can get to help get you through, hopefully till, late spring, summer is going to be helpful. All right, so some additional resources to help. Obviously, 43North and their Small Business Schooll. Launch New York is a great resource as well. Entrepreneurship Law Center, which is where I'm at the University of Buffalo. There are qualifications on that, but if you have any connection to UB, it might be worth considering. Western New York Law Center, Canisius Women's Business Center, Beverly Gray Business Exchange, Buffalo State Small Business Development Center. City of Buffalo has also put out a number of updates, and as well as the county. All right, questions. I think, Christian, you said you were going to hop in and hopefully read the questions.
Yes. So thank you so much, Matt. That was a lot of great information there, and we got a good amount of questions in the Q&A section. So I'll just jump right into the first one here. What are the estimated costs and steps to converting a DBA in Erie County to an LLC? And what are the advantages of that? Is there any taxation difference?
Yeah, so converting a DBA to an LLC it's actually not how that happens. A DBA isn't a thing, right? It's just a piece of paper with the county that allows you to use that name. And so what you're really doing is just forming a formal entity. And there are a couple things you want to make sure you do. To help with any confusion, you'll want to cancel your DBA with the county, really cheap, less than $30, I think, to file that form. Prior to COVID, you could just walk in, grab the form and file it. I'm not sure if they're open right now. I think they actually are, but something to check on. And then once you've done that, or even simultaneous with it, you can form the LLC, and the protections that you get from that from a liability perspective is a huge advantage over a sole proprietor or a DBA. There may be tax advantages depending on your particular circumstances. For instance, LLCs, depending on what field you're in, can take advantage of qualified business income deduction, which essentially allows you to deduct 20% of your income from your income, which from a policy perspective doesn't make any sense, but you can take advantage of it. And so there may be tax benefits for you being an entity where you're not taking advantage of those things right now as a sole proprietor. But good question.
So the next question, if you're an S Corp and you are the only payroll employee, how does the sexual discrimination training apply?
Yeah, on the plus side, I'll say you should do it, but it can apply to contractors and vendors as well. Now, I think I sort of noted this initially. It's not clear what the consequences of that will be, but if there was a claim from a vendor even, right, that you as a sole proprietor through an S Corp sexually harassed them, and that somehow ended up before the New York State, I think it's Human Rights Commission, that could be a factor against you. And so while it covers employees, it goes a little bit further than that and actually covers vendors, independent contractors as well. And so it is a good idea to do it. Again, I think I noted New York City Bar Association has a free online webinar you can do. Really is a matter of just not only educating yourself, protecting yourself from sort of unknown risks, right?
Yeah. So if you lay a person off, are you required to pay them sick time that they banked?
So that all depends on your particular policies and procedures. And I will say this, if you have not explicitly stated how you're going to treat it, then it will likely be held against you and in favor of the employee. And so this is where something like employee handbooks and benefits, where you set out explicitly how these things will be handled, come in, and are crucial. And not just having them, but making sure the employees read them and then having them sign off saying that they've read them, right? This is all because, you know, any ambiguities will be weighed against you as the business and in favor of the employee. And so making sure that these policies are well documented, that employees have reviewed them and signed off on them is actually going to be what determines that. They could be entitled to it, or you could explicitly state that they're not. It really just depends on what your policy is and what you've specifically put in writing.
All right, so this next one says, I'm planning to hire help to sell my product in a farmer's market, which is 1 day a week and around 22 hours a month. They were thinking of 1099 for those who will help them. What is your suggestion, 1099 or part-time employee?
Yeah, so right off the bat, the safest thing is to make them a W-2 employee. That's going to have the least amount of risk from a compliance perspective. However, sales are one of those areas where you will see 1099 contractors used. The key here is that you need to look at the specific factors, you know, control, you know, are you dictating the manner in which they do their job? It helps to have an independent contractor agreement with them where you're sort of being really explicit about some of these things, and then they're agreeing to hold you harmless and indemnify you if something, you know, kind of goes sideways. But sales is an area. Now, one thing to think about is how you're paying them. If you're paying them on commission for sales, there are really specific rules in New York State about what has to go into a sales commission agreement. If you're just paying them hourly to go do, you know, a farmer's market, for instance, at Black Squirrel, we used to use 1099s for tastings, right? We would basically just say, here's a time and a place, you can show up. We're not going to dictate what you have to do specifically, but here's the kit, go knock yourself out. But we had independent contractor agreements with them. And we, outside of giving them the time and the place, you know, didn't really control what they were doing. But that is a good question, and you really have to look at your individual facts and circumstances on that, and really helps to have an agreement in place.
Yeah. Okay, another question is someone wanting to know if they should copyright their design logo.
So your logo, you could copyright it, but actually the better thing to do with a design logo, under trademark law, you have what's called, you know, both a word mark and a design mark. The word mark will actually protect the actual name, right? So for Black Squirrel, to use as an example, we have the name Black Squirrel Distillery trademarked. But then there is what's called a design mark, which actually gives you protection over what that mark looks like. And so for Black Squirrel, I don't have one lying around here, or not one within reach. You know, we had a squirrel on top of the logo, and it was like picking up, you know, the circle on the eye, and it sort of looked like an acorn. And so we went and got that logo trademarked as well as the name, and that gives protection against somebody utilizing a similar design that might be slightly different name. And so that's going to give you way more protection than a copyright of that design would. Hopefully that answers your question.
Cool. And speaking of trademarks, the next question is, what's the average cost of a trademark? Is that a federal or state? Is that federal or state level? And they're asking because they're focusing on an internet-based retailer.
Yeah, so there's both state and federal. The state is way cheaper. I think it's like $50 or something. Unfortunately, it doesn't give you as much protection. Now, we're in New York State, so that is a significant, you know, percentage of sort of U.S. commerce. Certainly more so than, say, if you were in, you know, Wyoming, but it doesn't give you national protection, right? And so federal trademark, which is through the USPTO office, is going to give you significantly more protection, but it does cost more. Now, you might, putting an asterisk on that, you might be able to do this yourself through the USPTO office. There is a portal that you walk through. Before I was an attorney, I did one of these myself. There are some areas where you can trip up, but it is not the most complicated thing in the world. If you do it yourself, you're probably looking at somewhere between $200 and $300 for the trademark. If you are paying an attorney to do it, which is probably more what I would recommend, you're probably looking at a minimum of $1,000, and the costs really depend on what they call what class that you're actually filing that in and how many classes. And so if you just file in one class, you're looking at probably around $1,000 minimum. If you're filing in multiple classes, which have multiple filing fees, the price can go up substantially. Good question.
Okay, so the next question is, how should I file when I and my husband are 50-50 partners in our LLC company?
So I'm guessing this is asking about their personal tax filing. That is going to really depend on your personal circumstances. There may be instances where filing married but separate makes more sense than filing married together. Depending on, for instance, do you have student loans? Are there caps on, SALT taxation deductions that maybe you can get around? There are some things to think about, but that is definitely an accountant question. And while I can sort of point you in the right direction, I would have to defer to an accountant on that one. And if that wasn't what you were talking about, please just pop the question in the Q&A and I'll clarify.
All right, so the next question is, where can I find the most up-to-date info that will help me figure out exemption, non-exemption qualifications, minimum pay requirements for New York State, and whether or not business size is a factor? And that may be another kind of accountant question, but if you have
no, that actually, so I'm not supposed to engage in sales here, but there is a blog post that an attorney I work with actually just posted on this. I don't think we have a chat, but if you go to colliganlaw.com and you find Joe Saley on there, he just did a post on this a couple weeks ago, and he put together most of this in a blog post, and you can go and actually read through and see what those requirements are and see what apply to you for free. So I feel like that's not sales, right?
So,
Yeah. Yeah.
all right. So what category does PLLC fall under in sole, S Corp, C Corp, or LLC?
Yeah, so this is a really good question and not something I covered because I didn't think there would be any professional companies on here, but I guess that was a mistake on my part. So there are what we call professional entities in New York State, and that's both a PLLC and a PC, and the P literally stands for profession. These are entities which have to be licensed. The owners of them have to be licensed with New York State. And so, law firms, medical practices, dentists, there are about 40 or 50 of them that are listed out in the New York State Department of Education. If you aren't one of those licensed professionals, you're not going to use a PLLC or a PC. They are only there for the professional entities. And the reason being is that it essentially accepts out professional malpractice instances from the limited liability protection that the entity would basically otherwise have. And so that's why those exist. It also makes sure that people aren't engaging in the practice of, unauthorized business in areas that are licensed. And so if you are one of those businesses, important thing to note is that you should be using a PLLC or a PC. If you are not, then that's something that you should talk to your lawyer about and make sure you're correct. And there is a little bit of nuance to that, but that's the general rule.
Okay.
Good question.
Right. So the next one would be, can you have a subsidiary company under your main company? How many subsidiaries can you have? And can you have a 501c3 under an S Corp? So basically they want to know, can you mix types of companies under your main company?
Yeah, I'm just writing this down so I pick up all of them. So the short answer is yes, you can have subsidiaries. But as you can imagine, I wouldn't be a lawyer unless I said, it depends. S Corps cannot have entities as their owners. And so if you were going to try and have an LLC as the sole owner of an S Corp, doesn't work. Can't do it. Federal statute basically set that out. Purely speaking, you can have an unlimited number of subsidiaries under a parent company. If it's a LLC and it's a single member LLC, it's a disregarded tax entity. And so for tax purposes, that actually just flows up to the entity above it. That actually can simplify things. This is a strategy that's used really often with people who invest in real estate or have rental properties. They'll have basically a holding company on top, and then they'll have all of their properties held in individual LLCs. And so they may have 2, 3, 5, 10, 20 LLCs underneath that holding company. So you can do that. 501c3 is a little bit different. There technically are no owners. of a 501c3. It is a nonprofit. There are members, there are directors potentially on how you structure it. So it could not be a wholly owned subsidiary of a for-profit entity. But you could have an affiliated 501c3. You sometimes see this with businesses who start charitable divisions, right? Or who have a charitable endeavor that they want to put money and effort into. Another piece here, in case you're just thinking about it, 501c3s, or frankly, any nonprofit corporation, because you can have 501c6 or 4, there's a whole host of them, can have subsidiaries that are for-profit entities. So a 501c3 could have or be an owner of an LLC that was a for-profit entity. However, that can create some complicated tax issues for the 501c3, because it then can actually have income that is from a for-profit entity, and you might end up having tax liability for that. So short answer is yes, but it's obviously fairly nuanced and depends on exactly what you're trying to do.
Okay. All right. The next question is wondering, do sole proprietors and single owner companies qualify for a PPE loan or grant?
The PPE through ECIDA, I think, is what you're referring to. If you're referring to PPP loan / grant, yes, you can as a sole proprietor apply for that, and I would encourage you to do so. If you're referring to the PPPE grant through ECIDA, which is the reimbursement grant, you'd have to check on that one specifically. I've not actually had a situation where sole proprietors applied for that and had me look at it. So off the top of my head, I don't know, but I do know that the county has the application for that online through the ECIDA. And also I think the city has that too. So, listen, the worst thing they're going to do is say no, right? So worst case scenario, put your application in and, maybe you wasted, 15, 20 minutes, but, it would be worth looking into for sole proprietors.
Okay. The next one is just a request. If you could please go back to the last slide with the law contact info and business help.
Resource help?
I believe that's what they're looking for.
Okay.
Yeah.
Yep.
Perfect. And then the final question, and just for that person as well, this will be up on the 43 North YouTube page this afternoon, and we'll be sharing a link out as well. So for anyone who wants to go through and see specific slides, you'll be able to kind of go through that and use that video to kind of check back and pause and gather any information you may need.
And if you have questions, here's my contact information. I also have open office hours, and so do dozens of other business professionals in town. And so if you're looking to connect with somebody, there's a lot of us who volunteer our time to mentor and give back. You can go to openofficetime.com and find us. I'm on there, and links to my Calendly. You can select a time. I think it's Monday mornings. It used to be for coffee. Nowadays it's just a Zoom, but we'll get back to coffee eventually.
Exactly. All right. So the very last question here is a person looking to make sure that it's possible to use the DBA under a pre-existing LLC. So basically they have an LLC and want to start another business using a DBA and want to make sure that it'll work. Yeah.
And so the short answer is yes. However, the county DBA is not actually how you do that. The county will take your money and let you file the form, and you will probably think that you're all set. However, that has no legal effect on the actual LLC. What you have to do is file what's called a certificate of assumed name that gets filed with New York State. It's essentially the same idea. You're just allowing the business to operate under a different name or a different brand. And instead of going out and filing a new business, you just want to use a different name. It's a little bit more expensive. I think it's like $125 with New York State, whereas the county is obviously like $35. But that is how you actually use a different name with your LLC. Good question, because people actually mess this up all the time. So,
yeah, that does seem like a very, very kind of nuanced
thing. And you'd think that the county would actually tell you that that has no legal effect, but I think they just want the $35. So.
Makes sense. All right. Well, that's it. That was our last question, Matthew. Thank you so much for your time and your expertise this morning. I think it was super helpful for everyone who attended the session. Everyone who attended, thank you so much for joining us. We really appreciate your time as well. Stay tuned. Like I said, the video and the recording of this will be up on 43 North's YouTube page this afternoon. And our future sessions are open. So go to 43north.org, check out the events page, sign up and register for the next few sessions. We got some great ones coming up. Thank you, everyone. Have a great rest of your day.